You see, lawyers like to speak about judicial power in terms of jurisdiction of courts, what courts can do, and the doctrine and decisions that they make. And in Nigeria, that's been the stock in trade of what we do, what we study in the law schools. What we don't do well is look at judicial power as the insertion of courts and judges into decision-making as to who rules us, how our votes count, and how our country is governed. And in that sense, judicial power is actually not just about the doctrine and jurisprudence of the courts, but really about the things that occur beyond and before the courts exercise jurisdiction, and the interests that define how the courts then come out after they have assumed jurisdiction and chosen to exercise it. And that has never really been part of what we discuss in our studies of the legal system, largely because we are thought to believe that judges are some kinds of saints that come from outer space and nothing they do implicates anything other than what you see in court, which every one of us knows is not true. And if you noticed, since about 2003, progressively, most of our elections are no longer decided by the people, they're decided by the courts. And that has got tremendous implications for the nature of not just of politics, but also of judicial office and judicial independence. In terms of political office, it means that the promise of the Constitution that the people are sovereign has been eviscerated. In terms of judicial appointments, it means that the politicians are now more impressed by and interested in who gets appointed because they know that ultimately their pathway to office depends not on the people, but on the judges. That also then means that judicial independence and judicial office has become a site of contest, not merely in terms of whether or not we get suitable people there, increasingly we don't, but because that is the way politicians guarantee themselves that they get to office. And this is what I try to do in my new book, which is titled The SELECTORATE. And SELECTORATE theory, of course, emerged in the aftermath of the collapse of the Berlin Wall to describe how elites in transitional societies manage access to power and retention of power. I do not address this in the Nigerian context by way of theorization. This is meant to be a narrative, a narration of how the emergence of a judicial selectorate has evolved in Nigeria and how that judicial selectorate has methodically been set up to topple the people and set themselves up as judicial sovereigns, determining who wins and loses and who rules the country, and why this is very dangerous for Nigerians. And the story begins from the Lancaster House negotiations from around 1953-54 and continues until date and is ongoing. And I mean through this to actually catalyze a conversation amongst citizens as to how what we want for a country. If we want a country run by judges and politicians and their sons and daughters and mistresses and girlfriends and boyfriends, or whether we want a country that belongs to everyone who comes from it and who lives in it and who descends from it, in which all of us can decide who rules us and on what platform. That's a conversation that is important. That's a debate that's essential to the future of our country and whether or not our children have a different kind of country and a promising kind of country to live in. And ultimately, it's a conversation that is going to shape and frame everything about whether Nigeria succeeds or fails as an experiment in coexistence. And I invite you into a conversation that I hope we all can engage in together about the kind of country we want to have, but also, quite honestly, about the kind of legal profession that we choose to build for our country. And I look forward to getting involved in that conversation. It's a contact sport. Welcome.